Delighted to have from the Wisconsin Institute for Law and Liberty, Lucas Vebber, standing by to talk about a big case. This was last week. The United States Supreme Court decided unanimously, which is not something they tend to do, that the Wisconsin Supreme Court just flat out violated the First Amendment when it denied the Diocese of Superior's tax exemption for charitable work. And Lucas, I'm going to let you kind of describe the bizarreness of this case because it didn't make a whole lot of sense.
Yeah, and good to be with you, Vicki. This case goes back almost a decade. So Wisconsin law provides an unemployment insurance program. Employers are required to make payments into that program. That program then pays out benefits to employees if they ever need to access the program. Most people are familiar with the program. In this case, the state law exempts organizations which are operated primarily for religious purposes. So the Diocese of Superior has 4 social service organizations where they provide services as part of their religious mission to the public at large. The church doesn't discriminate on who needs these services. They just provide them to anybody who's in need as part of their charitable activity. They sought a determination from the state, from the Department of Workforce Development, that they were exempt from the law. The state denied that exemption, and that kicked off a very lengthy legal battle over the ensuing decade. So first thing they did was an administrative appeal, went to an administrative law judge who actually sided with the diocese and said, no, you are eligible. They then appealed that, the state did, appealed that to what's called the Labor and Industry Review Commission, which is this judicial body at the state level that hears unemployment insurance appeals, who overturned the ALJ, so they again sided with the state. The diocese appealed to the circuit court, which again flipped back and sided with the diocese. It then went to the Wisconsin State Court of Appeals, which sided with the state, and then ultimately to the Wisconsin Supreme Court, which issued a divided 4-3 opinion, which denied the unemployment exemption here from the Diocese of Superior. And that was a very, very divided court. Justice Rebecca Bradley wrote what I would describe as a blistering dissent, explaining the many ways in which she believed the majority opinion to be wrong there. I think most legal observers at the time agreed with her and thought that the state Supreme Court opinion was egregiously wrong. The Catholic Charities Bureau then petitioned the U.S. Supreme Court for a writ of certiorari to review the state Supreme Court's decision under the First Amendment. The U.S. Supreme Court took that case, and as you noted just last week, released a 9-0, a unanimous opinion reversing the Wisconsin Supreme Court. And that was a tremendous win for religious liberty and, frankly, a stain on our court. I think it really highlighted.
Scary.
Yeah, it's certainly.
Here's why. They said that the Diocese of Superior, in its execution of its charitable organizations, wasn't sufficiently religious to call itself a religious charity because they helped people who were non-Catholic. What? So if you're a faith-based organization and you help everybody, you're now at risk of losing your tax exemption because you would help people who are not in your denomination.
Exactly. And, the legal term of art we use when a legal principle is so obvious that everybody just knows it, we call it black letter law. And it's black letter law that government has to be neutral when it's looking at a religion and comparing it to other religions. So government can't, for example, come in and say, hey, we're going to provide a benefit to a religious organization and then sit there as judge and determine who qualifies as a religious organization or whose benefits are religious enough. And that's what they did here. They essentially said the Catholic Charities Bureau wasn't religious enough to qualify for this exemption. And Justice Sotomayor, who is not known as being a conservative by any means, wrote the majority opinion for the U.S. Supreme Court. And my favorite line from the opinion was, there may be hard calls to make when policing this rule of neutrality, but this is not one. And I think it was, the fact that it was a 9-0 opinion from the U.S. Supreme Court, it really is, I think, a good sign for the public at large that religious liberties continue to be protected, but certainly unfortunate for Wisconsin, where our Supreme Court historically has actually provided much better religious protections than the federal Constitution. So this was
Yeah, but not
a stunner
anymore.
when we saw it. Yeah, it was a stunner when we saw it. And
The implications, does anyone know, what's the argument to try to choke off, to go after the Superior, the Diocese of Superior? Was this also potentially could consume whatever Lutheran or Jewish or any other charities that were out there that were helping people who are not part of their religious faith? Was this an attempt by the state of Wisconsin to shut down charitable work by religion in general?
yeah, I think you saw what we saw in that case, especially at the state Supreme Court here, were a number of those other religious denominations filing amicus briefs supporting the Catholic Charities on that side. And I think it's for that very reason. I think they were afraid of kind of a domino falling and that they would be next. And everybody understands the black letter law here and the long held understanding and why the Wisconsin Supreme Court's decision was wrong. But and I think that's something that we'll see going forward now if the court takes any more cases along these lines. But it's good to see that the U.S. Supreme Court is willing to play a role here to hold them accountable.
Well, it's not just an unemployed insurance program. As I understand, the diocese hired developmentally disabled adults, took people who were difficult to employ. And so we're also talking about putting some fragile people out of employment. They also had a separate benefits plan to make sure their employees were taken care of. So it wasn't like they were just trying to skirt their responsibilities as an employer, correct?
100%. Yeah, and I've seen some commentators say the opposite of that, but it's just untrue. I mean, I think this is a good employer that has a program in place to ensure that their employees are protected. They're not a freeloading organization here by any means. This is something that the employees are protected, and the employer just wanted to get the benefits they were entitled to under state law.
Well, you can do more if you're tax exempt. All right, you can do more if you're exempt from these rules, which is why we exempt religious charities from these rules, or a lot of charities from these rules. So,
exactly,
if all of the charity or work had been shut down, we should describe what some of this is. Some of it's feeding people. Some of it is providing assistance for seniors to have transportation. Some of it is providing housing assistance. That all of that then would be shouldered to, let's say it's not just Catholics, but it's not just Catholics in Superior, Milwaukee and Madison, and then the Lutherans and the Jewish people and all their charities get shut down. I wonder what the many millions of dollar hit that would be to the state budget to pick up the slack for all of the work that religious charities do in the state of Wisconsin. Absolutely. I think that's a very good point. So let me ask about the concern we have as Justice Sotomayor. And by the way, a lot of people don't consider her to be, a Mensa member. But she said this is black letter law, basically. Our Supreme Court, these are not stupid people. They knew it was black letter law. You have to believe that. And if they were willing to do that based on ideology, what aren't they willing to do based on ideology regarding cases? Yeah, I mean, I think this case really highlights that, where there are kind of deep divides between the court, and the court has, makes decisions that are, really 4-3 decision is of course as divided as we can possibly get in Wisconsin. But where that happens, to have an added check where there's a federal claim involved here, to have the U.S. Supreme Court to weigh in is very important. Right, but not all of these cases are going to have federal components. That's true. That's right. Then we can talk about the cases. There is a case that is pending right now that would challenge whether or not the legislature has oversight of rules. That one terrifies me. There's the congressional redistricting case. That one probably has a federal, does have a federal component. So maybe that's appealable beyond the Wisconsin Supreme Court. But if they're willing to be ideological in a way that is not necessarily easy to see the federal component where we might be able to, to make an appeal, then we're stuck with the decisions of this court, and the decisions of this court could be wildly off. How about Act 10? Is there a federal component to Act 10? I don't know. Yeah, I mean, I think what this case does is it really highlights the need for the public at large to open their eyes, pay attention, make sure that they understand the need to maintain the Supreme Court of Wisconsin as a court of law, not a political court, not an ideological court, but a court of law first and foremost.
I think that's what the U.S. Supreme Court reminded them of in this opinion. That's really big when the U.S. Supreme Court unanimously overturns like that. I mean, that sends a strong message, and I sincerely hope that it's received.
I don't think so. I know you hope so because you guys practiced before this court, but it's so obvious. It's so obvious. It was screamingly obvious, even to Sonia Sotomayor. It was screamingly obvious to anyone who looked at this and said, "Wait a second, you can't do this. Obviously, you can't do this as religious discrimination." And they did it anyway. No doubt, Rebecca Bradley is a brilliant woman and is very clear and very persuasive. If she walked them through it and they said, nah, then they knew what the law was and they decided this opinion anyway. Again, so I'm thinking forward to this case on regulation in Wisconsin, which could essentially give Tony Evers and the administrative state in Wisconsin carte blanche on writing law, regulation that has the force of law. And this court, not, you having Rebecca Bradley explain the separation of powers to this court or the non-delegation doctrine to this court and them not caring. That's my concern, Lucas.
I think it's a very real concern, and I think we're going to see a number of cases like that over the next few years. So
yeah. Well, I hope Wisconsin Institute for Law and Liberty is there. I appreciate the time on the program. Thank you so much for joining me today.
Yeah, thank you, Vicki. Have a great day.